Hi, my name is Beatriz Refutation, and today I will be reading the speech for Aaron T. So I'll be reading Aaron's proposition that the right for ex-felons, probationers, and parolees to vote cannot be restricted. His two secondary claims are: one, the right for ex-felons is defended by the 15th Amendment, and two, the Voting Rights Act protects minorities from being prosecuted. In response to secondary claim 1 about the 15th Amendment, his first claim did a good job explaining why the voting rights of ex-felons should be restored by defining the definition of servitude, somebody who lacks liberty, and by arguing that therefore someone who is a parolee or probationer has their liberties more or less restored and are living among us as citizens. Before Aaron states that the 15th Amendment explicitly says that your right to vote cannot be restricted based on the previous condition of servitude, he provides a statistic stating that 500,000 people in Florida do not have the right to vote because they are ex-felons. This is a good statistic to include because it gives the audience some background on the issue, but it did need a citation for it to have credibility. Even though Aaron did a good job explaining why the 15th Amendment protects ex-felons from voting restrictions, it does not mention that although the remainder of probationers or parolees' term can be spent outside of prison, they still remain in the Department of Corrections legal custody. So a quote from the U.S. Supreme Court decision in Sampson versus California, June 19, 2006, says that an inmate electing to complete his sentence out of physical custody remains in the Department of Corrections legal custody for the remainder of his term and must comply with the terms and conditions for his parole. This shows that even though they are physically out of prison, they still remain in the Department of Corrections legal custody. So in response to secondary claim 2, the Voting Rights Act, Aaron uses the following statement to make an inference on racial motivations for prohibiting ex-felons from voting. Voting rights cannot be restricted by the person's ethnicity or gender, unquote, and then gives an example showing statistics that, quote, before the Civil War of 1859, only 38 of the states of the Union had a law restricting these peoples, which means minorities, right to vote. As of 2002, 96% of the states had a mandate like this, unquote. This is a big inferential leap or a hasty generalization to suggest that the change in laws before the Civil War and what came after the war was an attempt to suppress the ethnic groups. One evidence to disprove this belief was stated by Judge Alex Kozinski in the Court of Farrakhan versus State of Washington in February 24, 2004. There was no evidence in the Voting Rights Act that the felon disenfranchisement laws were being used in a discriminatory manner, nor any discussion of felon disenfranchisement at all, unquote. One of Aaron's evidence says that there is little doubt that the states have an equally substantial interest in preventing felons, especially those still incarcerated, from voting and potentially affecting elections, which is not supported by any explanation or proof that this is true for the country's states. Therefore, it might as well be used as a personal opinion. Even though Aaron's secondary claims suggest that the Voting Rights Act and the 15th Amendment must defend the voting rights of ex-felons, probationers, and parolees because they are not in servitude, the Voting Rights Act actually does not. The Voting Rights Act doesn't protect ex-felons, probationers, or parolees from disenfranchisement or the cancellation of the right to vote because, as stated on heritage.com, quote, both the original Constitution and the 14th Amendment specifically delegate to the states the right to determine qualification of voters and to disqualify anyone who participates in rebellion or other crime. Therefore, since Congress cannot override the Constitution or restore felons' right to vote for federal elections, the people of the U.S. and the elected state representatives must take their own decisions about felons getting back their rights as citizens. In conclusion, I thought Aaron's speech included some good points for allowing ex-felons to vote, but they were not strong enough to convince me that the Voting Rights Act and the 15th Amendment protects ex-felons to be able to vote, because by not allowing them to vote, it contradicts the Voting Rights Act or shows to be an attempt to suppress ethnic groups from voting. Thank you.
Well, you start off pretty well by identifying the claim and the secondary claims. And then I thought you got a little off track on the first point, because it sounded like you're basically giving an evaluation of the speech rather than a refutation of the argument that's there. You kind of deal with the 15th Amendment, and you kind of accept the premise that the advocate's presenting here. You accept the definition of prior condition of servitude as meaning the same thing as being a prisoner. I'm not exactly sure that that's an appropriate response on that point. And in fact, your evaluation of it doesn't really take a position so much as it says, well, you made a good argument on that. This is, like I said, you don't want to be making an assessment of the argument. You want to be responding to the argument. And I'm not sure that you did that. I did think that the second argument, or the second part of the argument that you're making on that point, that says that they are basically still in custody of the Department of Corrections, that does address the issue a little bit more from the perspective of somebody who's contradicting the position that the advocate took. So I was a little concerned that that was going to be a trend in the rest of the presentation. On the second point, though, that's not really the direction you went. You went directly at the claim that the advocate was presenting and suggested that there was a false inference being made here, that it was due to racial animus that these laws were put into place. You had a good piece of testimony from a judge who ruled in a particular case that suggested that the Voting Rights Act had not been demonstrated to be used in any discriminatory manner. You challenged the absence of evidence to support the idea that a motive existed to suppress these votes. He just mostly asserted that particular point, so I thought that that was a reasonable press on that. And then you've got good information that suggests the Voting Rights Act is not really meant to address this issue, and you've got a constitutional principle that you present on that. So I thought that that argument was much more clearly applicable to the issue as a refutation. And then at the end of the speech, you kind of get back into the evaluative process again, and I'm glad that you thought he did a nice job, and I'm glad everybody wants to be supportive of each other, but generally I don't think that that's necessary, and in fact it sounds a little confusing sometimes when you say those sorts of things. I doubt that the defense attorney would say, wow, the prosecutor did a pretty nice job trying to convince you that my client was guilty, but I got a few issues with their point. I think you'd want to be much more assertive about saying they're wrong, they don't have the case that they're presenting. All right, thank you.